Hello, everyone. Thank you so much for joining us for part 2 of our 5-part webinar series. So you thought you knew health privacy. Today, we're going to be talking about how we got here, the federal constructs of health privacy, going back 50 years in the US. We hope we'll bring you some interesting content that's in addition to what we talked about in the first webinar. So we highly recommend, if you haven't seen it, please go back and watch the first webinar.
I was going to say, just to give kind of an introductory picture of what we're trying to do today, what we wanted to do was present an overview of how we would encourage people to think about health privacy in ways that are fundamentally different from what most people think and from what you would have thought if you were involved in health privacy these last 20 plus years. Mm-hmm. And so our first webinar is important to watch because it was kind of an overview of what we're trying to do. Today's going to be a deeper dive on HIPAA and Title 42, and we hope people will stay with us for the rest of it. We've gotten great feedback so far, so very excited for today in spite of a little technical difficulty.
Yeah, it's okay. It's technology. What can you do? We'll be talking about technology a lot today. So just a few disclaimers. As always, attending and listening to our webinar does not make you a Nelson Hardeman client. This webinar is provided for educational purposes only and is not offered at and really should not be relied upon as legal advice. We won't be so California centric today, but in future webinars, and as we were in our first webinar, there are a lot of California rules that we'll be talking about and in California context, but not so much today because we're focusing on federal law. And if you're considering what to do with the information presented in this webinar, definitely consult with an attorney to address any particular situation. We here at Nelson Hardeman are healthcare law experts, of course, but we're here today just to provide you some great information and food for thought. I'm Adela Katz. I'm an attorney at Nelson Hardeman, and sitting with me is our fabulous managing partner, Harry Nelson. You have a comment? Not sure.
Let's dive in.
Perfect. Just a brief agenda for what we're going to be discussing today. I'm going to do a brief overview of what is HIPAA in general, and later on, what is its substance use disorder information counterpart, 42 CFR Part 2, why they're important, why were they originally enacted, and when. We have this long 50-year history of this federal health privacy laws, and we're going to describe to you why it's important, why it was important then, why it's important now, and an overview of what's happened over the last 50 years, especially in the last 20 years or so with the HITECH Act, the big push for digitization of health information and interoperability, and understanding the big changes that are on the horizon, actually on the docket this year in 2023. So there's a lot to come, and there's a lot of convergence of these federal health privacy schemes, which we'll talk about later on.
So we wanted to start off by, we deliberately labeled today HIPAA in 1942, Title 42 CFR Part 2, because these are really Title 42 is not everybody who thinks about HIPAA. If you're not in the behavioral health and substance abuse world, you may not think of Title 42. It might not roll off your tongue that HIPAA and Title 42 go together. But when you look at their inception, you learn a tremendous amount about both laws, and so we think it's a great place to start. It predates HIPAA by 21 years, and so so that's a great place to start. So anyway, let's just do a kind of a brief run through, and we'll kind of explain why Title 42 is relevant, even if you're not in behavioral health. Here we go. Sorry. First of all, it's interesting to note, that the law is not, HIPAA stands for the Health Insurance Portability and Accountability Act. And it is, it's not, we don't call it the Health Privacy and Data Security Act, right? It's interesting just to point out that HIPAA really set out with a much broader agenda than just addressing health data, privacy, and security. In fact, if you look at the 5 articles, the titles that make up HIPAA, in fact, only one of them is really the relevant one that addresses the rules that we consider the sort of architecture of health privacy and health data security. And in fact, the other 4 sections all deal with employer issues, questions about the ability of employees to take their insurance with them, to continue their insurance after their employment, Ironically, a lot of that law has been in some ways superseded by the Affordable Care Act, particularly, for example, the concerns around pre-existing conditions. And we want to be clear, our intention is not to talk about that whole other part of HIPAA, but really to focus on Title II of HIPAA, which was titled the Preventing Healthcare Fraud and Abuse Administrative Simplification Medical Liability Reform. And the goal was to establish and enforce standards for health data, which was an important goal. It's what we're talking about today. There's some parts of it that we're not even going to address in detail today, the transaction and code sets rule, the unique identifiers rule. But that is just an important place to sort of say this rule came into being in 1996 for a broader set of purposes, even though it really was a landmark in being our first uniform set of health privacy rules at a federal level. So the important part of HIPAA, just as a quick refresher, is the privacy rule and the security rule, right? Privacy is the sort of core rules of HIPAA that regulate the use and disclosure of what we call protected health information. And that has a very specific definition by specific categories of people, covered entities, and later business associates in a very specific set of activities: healthcare, treatment, payment, and operations. The core constructs of the privacy rule are this concept that by giving a patient notice of privacy practices, not necessarily requiring them to sign anything, but just by giving them notice of how you intend to use their health data, you are then authorized as a covered entity to use their data for the purposes of treatment, for the purposes of payment, i.e. getting paid, and for operations, sort of internal administrative purposes related to delivering healthcare services. And that we call that TPO. The privacy rule was the source of the minimum necessary standard that you should only use a person's health data to the extent that the minimum necessary amount, and not disclose it excessively, not just have, just sort of feel free to do whatever you want with people's information. It required tracking of disclosures, and it established certain rights of patients to access and request correction of inaccurate data, and to protect the confidentiality of their communications. Alongside that is the security rule, the data security rule, which extends privacy into the zone of electronic communications, particularly electronic protected health information. And that has a whole set of safeguards that are required. And just at a high level, the key responsibilities are things like auditing and assessing risk for potential security violations. Adela is going to talk in a little while about the way that breach notification became such an important part of the HIPAA landscape, contingency planning for disasters or for things going wrong. And the important thing I would say to point out when we talk about HIPAA is HIPAA really flows from a compliance framework that predates it, right? The US sentencing guidelines in 1992 developed the idea of a compliance program with 7 elements of a compliance program. And when you look at HIPAA, what you see is an application of a general framework to compliance that the federal government took since 1992. That is to say, the appointment of leadership, a privacy officer, a security officer, the development of policies and procedures to set out the rules that were going to govern health privacy, and training, requiring training on those rules. So that was really just as sort of the key background. I think that's a useful way to understand what we're talking about when we talk about HIPAA. So just a couple of points. We talked about this on the last webinar, but it's very important. HIPAA only applies to very specific categories of people, right? We have a definition of a covered entity that includes health plans, health data clearinghouses, and healthcare providers who bill electronically, who submit certain claim sets electronically. Notably, it's not going to cover anyone who engages in what we call cash pay healthcare. That is, if your healthcare is being paid for by patients, if you're a provider who bills credit cards or who collects cash in any form from patients and doesn't bill insurance companies or government programs, you are not going to be subject to HIPAA. Right. And then the other key category besides covered entities is business associates. And that's a category of people who use or disclose protected health information on behalf of covered entities or in providing services to covered entities. So we, as a law firm, are a classic business associate, right? Your billing company, if you're a healthcare provider and you give them your health information to help bill, code and bill, they are a business associate. But it doesn't include people who get the information outside of the provider-patient relationship. That's not from the provider. And finally, there's this category of members of the workforce that applies. That's very important. Those are sort of the universe of who it applies to, and they'll be important because then we're going to talk about who it doesn't apply to.
I just want to make a
yeah.
quick comment. The category of business associates are so important right now because business associates were only made directly liable and responsible for complying with HIPAA privacy and security rules and breach notification rules. I think only in the last 10 years, really. There was no direct liability for business associates using, misusing, disclosing, accessing, throwing out, doing whatever they want to with protected health information just until about 10 years ago.
Yeah, so it's a really important point. I'll just share, and working with around HIPAA in the kind of when it came out before it was actually in effect in the late 90s and the early 2000s, a business associate basically was someone who, if you were a healthcare provider, you just gave them a contract, a business associate agreement, and said, here, you be careful. And that was the end of the story. It was only at the beginning of the Obama administration with the HITECH Act that we're going to talk about that we saw this new application. And it's an important point. It's a change, really only 13 years in the making. So we also have this question of what information is covered, protected health information, all these individually identifiable pieces of information, 18 identifiers. By the way, interestingly, it includes a lot of digital information, but not geolocation. But it's anything that connects people to the past, present, or future. So you always have to go through this analysis. Are you dealing with someone who's a covered entity under HIPAA, a business associate? Are you dealing with PHI? All right, there's a lot of questions that are going to, again, suggest that HIPAA is not global for all health privacy. It's specific. So, and finally, as we have the question of the breach notification rule and that was enacted in 2009.
Which we'll talk about a little bit later, but briefly, it took really 13 years for the federal government to step up to the plate and create any kind of enforcement of these HIPAA privacy and security rules, any kind of accountability for covered entities, and a little bit later on business associates. But there was no accountability mechanism, no penalties for breaching these rules, really until 2009, that passed with the HITECH Act. So that's pretty significant. So
a couple things that we just want to, part of our goal here was to get people to rethink health privacy. So very important, it's easy to beat up on HIPAA. I think it's important to say up front that HIPAA was intentionally limited in its scope to avoid federal jurisdictional overreach, right? The whole point was that really the United States, the conception of federalism, of how federal and state power are divided, is that the practice of medicine and generally healthcare operations, licensing of healthcare facilities, all happens at the state level, right? So why is the federal government involved? And basically electronic data transmission was kind of a jurisdictional hook to justify that the federal government was involved, because there was this interstate use of communications to submit these claims and insurance. That was kind of the underlying concept. It was not intended to be global. We're going to talk about Title 42, which predates HIPAA by 21 years, but it's also important to note that we also had all these state health privacy laws, right? Lots of ground here in California. We have the Confidentiality of Medical Information Act that was passed in the late 70s. We have the Patient Access to Health Records Act. We have lots of other state laws that were already in place before HIPAA came onto the scene. And finally, the limitations of HIPAA are that it obviously predates the kind of rise, the shift to a consumer-directed system, direct-to-consumer, healthcare being such a significant part of the U.S. healthcare landscape, patient-centered care. It predates smartphone devices. I think we can, again, we can criticize HIPAA, but I think it's also another way to look at it is that HIPAA was never intended to be global as a solution. It was really a piece of a larger puzzle to fill in and strengthen uniform standards instead of having a patchwork of state-by-state rules. So now this is really interesting and important. I think this is, another place where HIPAA gets misunderstood. HIPAA deliberately did not establish specific standards, right? Which is kind of a strange thing. You'd say, well, we're putting in place a national uniform rules for health privacy. Maybe we should say what those standards are going to be. And in fact, when you look around, what happened very quickly was that everyone sort of looked around. Where do we look? And ironically, the best practice and standard for a data privacy and security at the federal level was a totally unrelated government agency called NIST, right? The National Institute of Standards and Technology. And so that became a standard. The other thing is, in advising healthcare and life science companies, about their kind of what I call their HIPAA journey, their data and privacy security journey, the dominant standard that most companies aim for relatively early into their organizational life is SOC 2, right? SOC 2, not a healthcare standard. It was developed by the American Institute of CPAs, and that was that really still is today kind of a gold standard for security. And then finally, we get really only in the last 15 years, we get the emergence of what's called HITRUST, which is a consortium of industry companies, organizations that came together and decided that they wanted an even higher standard for healthcare. So it's very confusing, right? I generally, what I've heard from the people who we work with, who help clients on the way to HITRUST, is that SOC 2 involves something like 64 data privacy and security controls within your organization, and there's more than 200 when you get done with all of the categories for HITRUST. So it's a much more complicated standard. So that is a healthcare specific standard, but it's not within HIPAA. It was developed externally because HIPAA deliberately didn't attach it. And I guess just a few key points to sort of think about how does HIPAA fit into privacy and data security? It's very useful term that I always come back to is the CIA triad. That is, if you're in information technology, you know that well, stands for confidentiality, integrity, and availability. Those are the three values that you have with data, and HIPAA intersects with them, but they are a much broader set of concerns than HIPAA itself and HIPAA's requirements. It's very important to note, and this is just another thing that I'm always trying to emphasize with clients and with the healthcare industry, is really ultimately data privacy and security. It's not, when you talk about those three values, there are some elements that deal with people, meaning training them, and HIPAA certainly has something to say about that. There are some elements that are really around process and how and again, HIPAA has something to say about that, but a big piece of it is also technology, and HIPAA does not specify that, and that's why all these other standards come into place. So really, when you think about privacy and data security, if you're in healthcare, you need to be thinking about HIPAA, but you need to be thinking about a lot more than HIPAA. And so I guess that's how I would leave our point on this is that it's really helpful to think of HIPAA as establishing a framework that's hopefully uniform about the roles, the responsibilities, and the rules that healthcare providers, health plans, and certainly the traditional healthcare industry should be following. But it's just that. It's a framework that needs to be populated and is going to look different and leaves a lot of questions that have to be answered, and we have to look elsewhere in our privacy and data security landscape.
Yeah, and I wanted to make a point about that actually. So like Harry was mentioning, HIPAA does establish kind of this framework and even kind of general vague safeguards that should be implemented internally, externally. For example, the HIPAA security rule establishes very specific technical, physical security safeguards, which were on our previous slide, but which we didn't really go into. And they kind of establish general protections that should be implemented. For example, there's a lot of information about what employee workstation should look like, that computers should be password protected, files should be locked in certain cabinets, etc. So these are general guidelines that are outlined, but really the Department of Health and Human Services, which releases guidance about all of these rules, actually provides certain pamphlets and guidances specifically connected to NIST, cybersecurity frameworks, and says, hey, healthcare providers, you should use NIST's password protection regulations or rules or their frameworks. So all of this is very much interconnected, and the federal government recognizes that it's interconnected because it releases guidance specifically connected, hyperlinked to all of these different standards. So that's just a fascinating point in case anybody's looking for specific ways to implement these safeguards.
So Adela, let's turn to high tech and breach notification.
Yeah, definitely. So in 2009, you know, in the hot seat of the Obama administration's heavy push for the Affordable Care Act, there were laws that were implemented, like the HITECH Act, that were really geared towards achieving all the 3 points in what we call in the healthcare industry the iron triangle of healthcare, to address cost, quality, and access concerns. And so the HITECH Act really focused on giving consumers more autonomy, more access to their health information in a more efficient manner, geared towards digitization of health information, and trying to bring the US healthcare system in general into the digital era. And so what came out of the HITECH Act were many, many different rules and guidelines and, you know, important things for the healthcare industry, but primarily the 4 rules that we want to focus on, and we'll get deeper into the breach notification rule in a second. But what came out of the HITECH Act was the breach notification rule, which, like we mentioned, was the first time that the HIPAA privacy and security rules really enforced, the first time accountability came onto the scene. Patients were actually given rights to get copies of their medical records through electronic health record or electronic medical record systems. Those terms are kind of used interchangeably from different providers, specifically hospitals, because hospitals were the health care providers that have these resources to implement electronic health record systems. The minimum necessary disclosures were really emphasized. Healthcare providers should have a security plan in place, make sure that any protected health information disclosed to business associates or even internally to their own employees was used only at a minimum necessary level to protect protected health information. And annual federal audits were placed onto the scene. That means that all of these healthcare providers were now subject to all these requirements to do internal risk assessments, create all these internal policies, comply with the breach notification rule, and really be up to par with their systems.
And just a comment there, that, you know, it's interesting, you only find out if a system is working when you actually get evidence of the things that go wrong, right? So it's very interesting. I always worry if we're involved in a transaction, for example, and I ask for a log of, you know, kind of auditable events, and the company says, oh, there's absolutely nothing. You know, that that's actually worse, right? Part of what the government was asking with HITECH was to demonstrate that the system is actually being used, that there actually is a record, that you're checking what kind of access there may have been and whether there was a potential breach or unauthorized security incident. And so it's actually good news, not good news when you have a bad one, but good news that you have a record that these things are coming up. Because there's certainly, I always like to say there's only 2 kinds of companies in the world: companies that know that they've been that their security has been breached, and companies that don't know yet that they already had a breach.
It's happening all the time. So more specifically, the breach notification rule. The point of the HITECH Act in general, and especially the point of the breach notification rule, was really just a focus on transparency to consumers and to give consumers, like I said, access to autonomy over their own health information, the right to know what's happening, anything that goes wrong with their health care providers. Has any information been improperly disclosed, used, hacked, right? We're seeing a lot of phishing attacks, especially in the last 10 years, as technology is becoming more advanced, and so are hackers. And the breach notification rule really imposed these requirements on healthcare providers and their business associates to conduct really thorough risk assessments, and also mitigate any kind of risk of breaches, and also provide patient individual notifications and notifications to the federal government if necessary, right? If we reach a certain threshold over 500 consumers, about what's happening with their information, how it was breached, what the company is doing to protect against further risk. And so the one thing I do want to mention is that although this breach notification rule was kind of brand new, it looked really robust, the interesting thing about it is that it's actually really discretionary. There's a whole preliminary analysis that one has to do, you know, whether it's a provider or whether it's outside legal counsel, whether something actually is a breach, because security incidents happen all the time. An employee accidentally emails, you know, a patient's protected health information, maybe to a business associate or to another employee, maybe that wasn't working on that matter or something like that. Or really it was, you know, it was information that was hacked, maybe the spreadsheet was hacked, email system was hacked, something like that. So there's a first preliminary analysis whether something is a breach, And the definition of breach itself not only has 3 or 4 robust exceptions, but there's actually a really robust multi-factor exemption as well, in which a healthcare provider can actually, discretionarily, shift their mitigation tactics, et cetera, to claim that something wasn't a breach and it's not reportable. So the consequences I think that we've seen is that, big healthcare providers have been hit, really majorly by these specific breaches that have happened in the last 20 years. But I think small providers have been able to fly a little bit under the radar. And I'm not saying that they haven't complied or they've avoided complying with the HIPAA security rules, but I think they've been able to use that discretionary analysis to their advantage a little bit to avoid compliance with the breach notification.
Yeah, I would just add, I certainly, we take that seriously. We get asked to put these security incident memoranda of analysis together, and it's a serious thing. It's an opportunity as a healthcare provider to really demonstrate, to test, and you can't be, it's not a place for laxity, but it's a place where having good counsel and can really make a difference between something that looks like a disaster, a publicly reportable incident, and something that can be addressed internally. Because
what happens, unfortunately, is for some of these small providers, unfortunately, if they get a really scary phishing attack and their whole system is compromised, what happens is because they haven't been complying with these rules, all of a sudden they're at major risk of being fined, of being penalized by the federal government. Their reputation is at risk. So it's really important that internal policies are in place. Employees are trained and these systems are really set up well to account for any kind of breaches or security incidents of protected health information. So moving a little bit to the side, what else happened with the HITECH Act? Well, the huge thing that came out of it was the major incentive program to encourage healthcare providers, especially big hospitals, to implement electronic health record systems, and also to bring, basically just to digitize medical records. There's actually an interesting statistic that I found that in 2008, so a year before the HITECH Act was actually implemented, only 10% of hospitals actually use EHR systems. Kind of a scary number because that number only relates to hospital systems, right? That number has nothing to do with other healthcare providers, not your local, chiropractor, your local primary care physician. I mean, that's a pretty scary number. And so the HITECH Act said, well, we're going to do something about it. And the result of the HITECH Act was a $19 billion incentive program to help HIPAA-covered entities digitize their information. And actually, by 2017, 90% of healthcare providers in the country were actually using some kind of electronic health record system, whether it's something huge like Epic or kind of a cloud-based system, something that digitizes health records and gives patients access to their information. And so what came out of HITECH through this, digitization theme was this concept of meaningful use of patient information. The point of it was to reduce the cost of healthcare, improving quality, safety, efficiency of services, providing a lot of access to health information that people didn't have before. Somebody could be, securely provided their information on the patient portal, for example, shared with other healthcare providers. Again, going back to the theme of giving patients access and autonomy over their health information. And I would say, meaningful use from the standpoint of accelerating the move to electronic records and to digitization of our whole health information technology, infrastructure, it was a success. From the standpoint of reducing costs, not so much, right? It's very important to note this all sort of coincides with the Affordable Care Act. And it's really a point that came up was that, the idea was that we were going to reduce the cost of care, by having by having digital records and having greater efficiency and value. The reality is that like everything else in healthcare, no matter what the government does, it doesn't reduce the cost of care. We still have the most expensive system in the world, and meaningful use has not done anything to reduce that. Arguably, it's improved care. It's made it easier to analyze records and catch things, and it has potential in the future to make care more efficient. That's a separate conversation about how that is happening, but I think it's hard to give credit to HITECH for actually reducing the cost of care. Yeah, it definitely didn't reduce the cost of care. In fact, I just read an interesting study that says on average, and this is recent, It takes a multi-physician practice, like something like $160,000 just to implement an EHR system from scratch. And that's not taking into account licensing costs, maintenance costs, training costs, et cetera. So it's extremely expensive endeavor. I mean, the intentions are great, but whether it's reducing the cost of healthcare is a totally different question. What it did do is try to improve care coordination between providers. So that's a concept of interoperability, which it really tried to execute. I think, Harry, you might.
We'll talk more about
Yeah,
interoperability.
talk about
I'm very mixed bag.
Yeah.
So just a few kind of comments at again a high level. While HIPAA's evolved significantly over its 27 years, it continues to be outpaced by the threats and challenges to privacy and data security, right? And those are new data usage, new data access patterns, right? New technologies like geolocation, like internet search coming up as a form of a lost health privacy when people can geolocate you and figure out where you actually are getting your healthcare met, your healthcare needs met. And there's been this politicization of certain aspects of healthcare, particularly around reproductive health, that have called HIPAA into question and raised the need for other laws that we'll be talking about on our next several webinars. I do want to give credit where HIPAA has worked. This is actually information straight from Department of Health and Human Securities, right? Enforcement really began in 2003. So even though we call it the Health Insurance Portability and Accountability Act of 1996, really 2003 is the sort of the gun went off, so to speak, on the race to enforce HIPAA. And in that time, you can look at these as numbers as amazing of how much was done or how little occurred, but 300,000 plus complaints, 29,000 plus corrective actions and demands for changes in healthcare organizational privacy practices, 51,000 cases where there was some kind of early intervention or technical assistance that sort of eliminated the need for an investigation, like an informal fix. A total of 122 penalties and financial settlements, 133 million. That may sound like a lot, but I can tell you, if you're paying attention to the kind of potential liabilities that for healthcare fraud and for violations of other healthcare rules like FDA, 133 million is a very, very small number of penalties, small number of overall settlements relative to everything else going on in healthcare. And when you look at the issues that all this HIPAA enforcement addressed, some of it is about lack of safeguards, lack of patient access, impermissible uses. But some of it is really just more fundamental things like about patients' rights to access their own information, and it's not clear that it's been a transformative force. I don't want to take anything away from HIPAA, and for anyone out there who's been part of the HIPAA story, no offense, but I think we really want to focus for purposes of this webinar series on where HIPAA has either broken down or been irrelevant. Right. And so we've talked about the fact that it doesn't cover an enormous part of healthcare data. In fact, I would venture to say the majority of health data lives outside in organizations that are outside of the covered entity and business associate construct. Right. There's this whole issue of HIPAA. HIPAA sort of assumes that anytime a law enforcement or government agency asks for records, that's got to be legitimate, and it creates an exception to allow records without patient consent. But of course, living in the post-Dobbs era, that's become a concern, right? We now have state versus state conflict between states that are protective of reproductive health rights and states that are seeking potentially to enforce laws that would criminalize certain reproductive options, pregnancy termination and abortion. And so I think there is HIPAA doesn't really get to that issue. It doesn't address all these different forms of post 1996 health data. And again, we touched on it in our last webinar, but I think it's just important to note that really you could see kind of the limitations of HIPAA in the aftermath of the repeal of Roe v. Wade, when really there wasn't much to say about what HIPAA could do. It didn't offer a lot of protection either to patients or to providers. The government essentially just said you don't have to necessarily provide records, and so when another state asks for them, so it's a limitation. But we want to turn to the subject of how HIPAA has changed. I just want to make one final point going back to the interoperability issue. I think this is fascinating. just as we were talking about a second ago, that HIPAA doesn't really address the potential for governmental overreach, it also doesn't really address, this push for interoperability kind of imagines a world where it's critical that your healthcare provider have access to all information about you in all settings. Well, lo and behold, we live in a world where that's not necessarily the case, right? Certainly in the reproductive health context, you can think of cases where patients might choose not to seek healthcare if they're worried that other people will see that information, including other healthcare providers who have very different feelings about it. We also, I don't know if I mentioned in the last webinar, we've had this fascinating issue, and I don't mean to pick on this one company, DoseSpot. They kind of piggyback as a software on SureScript, one of the big e-prescribing platforms, and really, what keeps coming up, and this has been an issue is that in an interest in creating interoperability, where a provider in one context can see the prescriptions that a different provider wrote for the same patient and coordinate, this software makes them transparent. Now there are places where we feel really strongly that should happen. Every state has a prescription drug monitoring program, which is intended to cover controlled substances, right? We consider the risk of potential diversion or abusive behavior and danger to patients from controlled substances, from, for example, opioid pain medications, to be so serious that we want to make sure that every provider who is potentially prescribing or dispensing them is able to check and make sure that this patient isn't also getting them elsewhere. But not so with everything else, right? We have lots of cases where people are embarrassed to go to their traditional healthcare provider and they want to go to a telemedicine provider for other conditions. And most people, obviously there's room for disagreement about privacy. Maybe some providers think I should know everything about you, but we live in a world where people have the ability to try to contain and control information about themselves, and are very unhappy when they find out that some of this interoperability is working against them. It just is an interesting, curious case where this goal of interoperability, ironically, I don't think we've done so. It still is a major, major challenge. If you go to any kind of health information conferences, HIMSS and other conferences, it's pervasive issue that we really have not gotten there yet, and criticisms of all the big EHR providers for kind of dragging on this. But I'm not even sure that it's a value that is fully something that patients would support. And it's an interesting tension between the interests of different stakeholders.
And continuing on that theme, I think it's important to, go back to the groovy 70s and talk about different kind of information that I think perhaps a lot of patients would want to keep segregated from their other providers. So back in 1975, the federal government was taking note of, I'm assuming, an increase of drug use, an increase in psychology practices, the advent of substance use disorder concerns in general, and also the stigmatization of, addiction recovery. So they passed the first health privacy law in the US, the 42 CFR Part 2, which is now retitled to Confidentiality of Substance Use Disorder Patient Records Act. They recently changed the name a few years ago. Anywho, we consider it the grandparent of all health privacy laws, and was specifically created way back when only to address concerns about substance use disorder information. Had nothing to do with any other types of health information. It was created in its original form, didn't have any kind of enforcement mechanism, also didn't have any kind of accountability measures, no penalties for misuse or breach of this kind of information. And it didn't align with HIPAA when it was passed in 1996. Nothing happened when HITECH passed in 2009. And only now in 2023 are we trying to see the federal government kind of converge these two giant health privacy schemes. So a little bit about 42 CFR Part 2. Like I mentioned, it was created to protect specifically substance use disorder records. So that's not to be confused with or conflated with mental health records. Those are actually separately covered under HIPAA. There's a whole section about psychotherapy records that's protected under HIPAA. Basically any record connected to addiction recovery, addiction services, being treated in an addiction recovery facility, rehabilitation facility, anything like that. And again, the impetus for 42 CFR Part 2 was originally the concern that there's a risk of stigmatization of people that are dealing with addiction recovery. They might be stigmatized by employers, other kind of healthcare providers, getting access to different kinds of services, what have you. Like I mentioned, there's never been any kind of real enforcement mechanism proposed until right now in 2020 and, reinforced in 2022, and it's on the docket now in 2023. There's been this attempted convergence of the HIPAA breach notification rule with 42 CFR Part 2 to kind of mirror those rules and regulations and mirror the breach notification rules that now substance use disorder providers will have to adhere to. All is not lost, though. I'm sure you're asking yourself, how was substance use disorder information protected for 50 years? Well, if those substance use disorder facilities and providers are covered entities under HIPAA, then that information really is protected under HIPAA. However, the issue still is that substance use disorder information is so sensitive, oftentimes more sensitive than other types of health information protected under HIPAA, that there really hasn't been yet a way to specifically protect that sensitive information. And that's what the federal government is trying to do today.
By the way, I just want to make a comment. Title 42 is there's a lot of lessons about how not to write health privacy laws. It's very confusing when you read it about who it actually applies to. It seems to suggest perhaps that everybody is is working in a federally, in a federal environment just by virtue of having a DEA. If you're a DEA certificate holder, which is every physician in America, you're subject to potentially the Title 42. So it's super confusing. And one of the big challenges we've had with clients going through it is it's not clear it's being enforced, and it's not clear if it always applies. And I think it's taken time, and now here we are, some 45 plus years later, finally reckoning with them and harmonizing them. And I think it's a valuable moment, certainly for the behavioral health community.
Definitely. So the last time that Part 2 was kind of substantively amended was 6 years ago, but before that, all the way back in 1987, that's a little scary. But in 2017, there was this push to digitize, specifically substance use disorder information to kind of address interoperability issues. Not sure how successful that is, but again, these concerns are being brought up today with this convergence, this attempted convergence of HIPAA in Part 2. And like we mentioned, the potential harm for 50 years of these treatment providers failing to comply with stricter Part 2 rules and protecting information, not having any accountability for protecting sensitive information, is the risk of treatment providers placing substance use disorder patients at risk of, being stigmatized by employers, especially disproportionately in lower income communities, where perhaps they might disclose that they've been to a treatment center and employers discriminating against them, failing to, not being able to get open up bank accounts, for example, getting certain housing opportunities. So that's a huge risk that's been, prevalent in the last 50 years that is trying to be addressed today. So let's talk a little bit about what's on the horizon, what the federal government is trying to do. November 2022, the federal government released a final rule trying to mirror certain HIPAA rules and regulations with Part 2, and obviously, recognizing again digitization and interoperability concerns, and that's just what the federal government is trying to emphasize over and over and over again, because it hasn't seemed to be working. They're trying to implement different mechanisms to increase patient access, and also force providers really to comply with any patient requests for access to their health information, including access to sensitive substance use disorder information. So whenever the federal government tries to pass and then passes one of these big rules, especially when CMS is involved, all these agencies, all these professional associations flock to comment on these rules, how it's going to affect their stakeholders. And so I just wanted to point out a couple of interesting comments from the American Hospital Association in response to this final rule. In fact, at the top of this slide, you can see that the American Hospital Association itself calls the Part 2 regulations out of date, arbitrary and confusing publicly. And it says that although it's thankful for the federal government trying to converge these two health privacy schemes and really increase accountability, they're very concerned that the interoperability wouldn't work in this context because there's really no way to segregate regular health information and mental health records from substance use disorder information. Because, think about it. If these two major health privacy schemes were converged and all of a sudden healthcare providers had access to health information, mental health information, and substance use disorder records, all of that would technically be available to any provider looking at this patient.
I want to say, by the way, I think this is an important concern. The AHA may be raising this just from a practical standpoint,
Sure.
But there are lots of cases where a person who's in recovery, might have additional sensitivities that are important for other doctors to know. We have way too many cases where a person who was in recovery from opioid addiction was given opioids post-surgically and couldn't tolerate them and was at a different level of risk. I have lost friends from that very thing happening, and it is a really sad reality. So in a way, the irony of sort of Title 42 is that although it was intended to prevent stigma, this sort of continued separation of records related to addiction treatment from everything else, in my opinion, it's a relic of a different time, and it's not productive, and yet it remains part of the landscape that healthcare providers need to deal with. And even in the past week, we've had objections made to producing records on the basis of Title 42. It's really it's a really curious thing.
Here's just some additional commentary from the American Hospital Association, where they're addressing their concerns about the inability to segregate patient records. The new rules certainly don't address how to segregation period. And I think electronic health record systems maybe aren't up to par yet, or haven't, developed as quickly as these rules have to address these segregation concerns and giving patients the ability to provide this record, but not this record. And so we'll see what happens as all these rules are on the docket. So let's talk about these proposed changes.
Terrific.
Yeah. So here's some of the proposed changes to HIPAA that are going to be made, and then we'll discuss the proposed changes that are going to be made to Part 2. So as for HIPAA, patients are now going to be able to view and photograph their PHI in person, which means that if patients come to any kind of healthcare provider, they're going to request access to their PHI in person in order to photograph. I think I'm predicting that there might be some concerns about significant downtime or cost associated with stopping operations, running to go get these records and producing them, printing them out if that's what patients are requesting.
Yeah, this is this rule is a head scratcher for me, because I can tell you from a couple of decades of working with healthcare providers that most healthcare providers and most health facilities don't have dedicated spaces set up for people to come and view their records. And honestly, then now you've got to not only find the person's records, but make them available, and it's just the whole thing makes no sense. Like I gotta wonder who came up with this idea.
And also, more of a head scratcher for me, at least, individuals can direct their healthcare provider to send their ePHI to a personal health app. That raises a huge red flag for me of FTC concerns, right? Because what personal health apps are we talking about? Who's going to be sending what to whom? Are there going to be agreements in place? Business associate who knows?
Yeah, this is it's complicated. We've had the whole subject of personal health records and how they intersect with HIPAA is complicated. I personally am in favor of more people being able to manage health records in their own format, but you're raising a great question of exactly what that format is and what rules that format is subject to, a subject that Google and Microsoft and other folks have really argued strenuously about.
Yeah, definitely. Are there any proposed changes on this slide that you want to address further? I think I wanted to highlight those too.
No, I think that's I think it's just what you're seeing is a new level of attention to greater patient access and patient autonomy. I would just say that these are all rules that reflect yet another step in the move to a patient-directed, patient-centered healthcare world.
Yeah, in fact, the time to provide access to PHI has been reduced in half, which may be significant, depending on the type of healthcare provider. Are we talking about a big hospital system? Are we talking about your local primary care provider? So that might be an issue for different healthcare providers to provide timely access to projected health information, and also depending on the amount of healthcare information. What if a patient comes to a hospital and requests their entire 1,000-page medical record? Like, that might be a huge issue, may be very costly, very time consuming. So
yeah, this is tricky stuff. I have to say, I don't think it's I don't think that it's a question of, certainly we're expanding people's rights, but are we actually making it easier for patients or providers? Clearly not. This is a lot of additional new requirements on healthcare providers, and we'll see how much actual benefit to patients.
Yeah, I think all these rules are being implemented, but I don't know if there's being surveys conducted to really see who would actually take advantage of these new rules. I think the issue might be that consumers maybe won't take advantage of a lot of these rules, and providers are going to have to implement all these new internal policies to address these new rules. And I'm not sure how you feel about
yeah,
that.
well, I think there's a few things to say. On the patient side, we have very different subsets of the American patient population, right? You have some people who are incredibly fastidious about managing their care, super interested in all their data. And then you have a huge middle that really is not interested in this unless and until, God forbid, someone's dealing with a chronic condition, with diabetes, with other issues, and this data becomes important. I can tell you the folks who I always see are very, very interested in all the records are government agencies, right? If you're dealing with state licensing agencies, you know, the paradigm that they imagine is that before a healthcare provider sits down with the patient, they've reviewed not only their past records of the patient, but all the records of other providers who've seen the patient. And only then are they actually making decisions about people's healthcare. If you actually talk to providers today, I don't know any provider who really lives in that world. And most providers are sort of forced to deal with very difficult records. These records are actually a challenge, right? A potential source of liability if you missed something that was previously in the records and you didn't deal with it. And the best thing that for most providers is to really get a clear diagnostic picture of where this patient is today, and not being forced to review volumes and volumes of records. So I think a lot of this it's misdirected. I don't, in my opinion, it's a real challenge. We're definitely upping the bar for both what providers have to do and what patients are entitled to. But I'm not sure that this is going to move the needle on in other ways.
Okay. Another rule that the federal government is proposing, there won't be a written acknowledgement requirement for a notice of privacy practices.
Right, which I think is only a clarification. I mean, just the way, a lot of organizations do ask patients to sign it and acknowledge it, which is certainly a good practice, but not a required practice. That's finally that's clear, and that's helpful.
Yeah, I think there are some requirements that are being imposed, but also a lot of things are being clarified by these new rules, and that's definitely a plus for healthcare providers who've been maybe living in a little bit of a limbo area with some of these definitions or rules and requirements.
Oh, we had a question, Adela. Do you know when are the proposed changes supposed to be implemented? I believe. Do you know?
I don't know.
The final rule, I believe I do
know that the comment period recently closed just a couple months ago, so I'm not sure when exactly implementation is going to occur.
We've had a series of previous delays on actual publication of final rules, but I suspect that on this we will see the publication before the end of 2023.
Yeah, I think I'm predicting it's going to be before the end of the summer. That's what I'm guessing, July or August. Yeah. Some other proposed changes to HIPAA. Covered entities can disclose PHI to avert foreseeable threats to health and safety. I think that's interesting, but I think that's also been addressed. There are exceptions to written authorization from individuals for disclosing PHI already that exists in HIPAA for public health emergencies and other situations, for law enforcement situations. So again, this is just, I think, another clarification that the rules are making.
One really interesting point here, there's this new rule about the transfer of electronic protected health information can only be made to electronic health records. So one thing that's very interesting in the telemedicine environment, and this goes to sort of the use of machine learning and AI in healthcare. Many healthcare providers, particularly in telemedicine and direct to consumer, have developed a lot of algorithmic models for sort of seeing when kind of very focused condition healthcare decisions can be made. Where all the pieces are there. A provider has a comprehensive set of information. There are no contraindications, and we see a lot of healthcare organizations moving towards those models, and they're not necessarily putting any of that into an EHR framework because it doesn't belong there. And so it could be valuable to have electronic PHI transferable into these other systems, but there's a resistance to the lack of transparency in that world. So it's a vote kind of against AI, if you will, in the HIPAA universe, but very interesting to watch how that plays out.
Definitely. And a few more proposed changes to HIPAA, and then we'll move on to part 2. Again, electronic health records now has a definition. If you can believe it, it hasn't had a clear definition this whole time. Healthcare operations definition has been brought in to include care coordination, case management. So that's really important when it comes to the breach notification rule. Excuse me, because there are specific exceptions for disclosing protected health information without requiring individual authorizations to other employees in the organization or business associates. So I think the fact that healthcare operations, in this TPO definition has been brought in to include specifically care coordination, case management, super important to kind of broaden and more clearly identify the scope of how protected health information can be disclosed.
By the way, really interesting question came up. Do you envision something similar to Title 42 CFR Part 2 happening in the abortion context?
Ooh.
A really interesting question. By the way,
the answer is yes.
So,
no, go ahead.
So it really interesting because Title 42 CFR, if you understand how healthcare regulations are promulgated as opposed to healthcare laws, for a new healthcare law to be adopted federally, it needs to pass both houses of Congress and be signed into law by the president. As you can imagine, it's very, very difficult to get bipartisan agreement on much of anything these days, let alone on any kind of health privacy rules. So, so the chances of federal law are very low. On the other hand, regulations can be promulgated, that is published as proposed rules, as we just talked about a minute ago, by a presidential administration through its agencies and become law. And it's fully, that is definitely on the table. And we are expecting to see that. Of course, the challenge will be when you start to get into a tug of war or a whipsaw, whatever analogy you prefer, between administration to administration. So, so the limitation, so it is very likely that for example, the Biden administration would support a Title 42 Part 2 style law regarding reproductive health. But the problem is that as soon as we have an administration that takes a different view, that's going to become a problem, and you end up in a much like we still see going on around the Affordable Care Act, for example. So it's much more likely that the energy is going to be towards protection at the state level, and it's going to be very interesting to see whether there will be a federal effort, knowing that it would still continue to be this hot potato from administration to administration.
So I think what's much more likely on the federal level is that there's not going to be, this huge privacy scheme related to reproductive rights, reproductive information passed anywhere in the near future. But what I think is much more likely is that the definitions, just like they're doing here in these proposed changes to HIPAA in Part 2, you might expand the definition of protected health information or individually identifiable information and add maybe new identifiers specifically related to reproductive rights and reproductive information, which we've actually seen super recently, just a couple of weeks ago. Washington State passed the My Health, My Data Act. So we're definitely seeing it on the state level.
We'll be talking about that on either our next webinar or the one after.
Yeah, on a different webinar. So stay tuned. But we're seeing it happen on the state level for sure. Probably in the next, I'm guessing, few years, we might see another proposed change to the definitions in HIPAA, accounting for reproductive rights and information. So let's switch gears a little bit to part 2. What's really interesting, and I actually put an asterisk here, a new proposed change is that there's going to be a single patient consent for future uses and disclosures of substance use disorder records. I don't know how you feel about that.
Hallelujah.
Hallelujah. Yeah, I put 2 asterisks. I thought it was super important point to bring up. I think it's going to be a huge shift forward in terms of optimization and really just making these processes more efficient and giving patients access to their information and disclosing this information to necessary treatment providers.
I think this is important just because, you know, what all of these rules do is put burdens on healthcare providers. And it really, when you talk about these 2 separate frameworks that you have to live under for addiction treatment providers, it is just it's overly burdensome. So anything that can be done to get rid of this need for separate consent at each point in the process is helpful. It really was a burden. Whoever wrote that never worked in the addiction treatment context, because that rule has been a nightmare. And I think this single patient consent for future uses and disclosures is a really an important change for anybody working around substance use disorders.
Definitely. And the other proposed changes that are on this slide really are just highlighting this attempted convergence of HIPAA in part 2. You know, like patients are going to be able to obtain access and counting of disclosures and request certain restrictions on the disclosure of their substance use disorder information. I think there's just a huge benefit and positive implication of these changes to increase patient access. I think maybe let's move along. There are going to be prohibitions on Part 2 record use and disclosure in civil, criminal, administrative, and legislative proceedings. I think that's hugely important. As we were talking about, there's been a 50-year-long history of stigmatization of this information, you know, used to discriminate against especially people in low-income communities that are suffering from addiction, and obtaining housing, bank accounts, jobs, and I think certain prohibitions on using this information willy-nilly in legislative and criminal proceedings is an effort to reduce that discrimination. Oh, and I think another important point is that the HIPAA notice of privacy practices that has to be given by all HIPAA covered entities is now going to include.
So essentially this is important because you can get an integrated notice to patients.
Definitely. And of course, the breach notification requirements are now going to apply to Part 2 records, which has never before happened. These are just some other avenues of converging the 2 privacy schemes. There's going to be a robust complaints process, and there are going to be penalties, which we've never seen before.
So before we come to this slide, I just wanted, by the way, we had another question that I wanted to address. It's real. The question was, under what circumstances can protected health information be processed overseas? Do out-of-country healthcare providers need to sign business associate agreements to review cases? It's a great question. What HIPAA, of course, is addressed to the United States and not to foreign providers, but it's been a huge question and problem as so much of our data is going overseas. Many healthcare providers are transmitting records for analysis into workforces all over the developing world, for example. You know, for example, some of the large national radiology companies and dermatopathology companies, you know, will shift the records. Essentially, images are taken and they first go to a country in the developing world where a doctor looks at them, not a licensed US doctor, yeah. And then they come back, so that what's really happening is that the US physician is is really giving an overread or a second read, not only of the image itself, but of the interpretation. Likewise, we've seen billing and coding activity, revenue cycle has moved overseas. So it's a great question, and HIPAA does not. There is no enforcement of HIPAA out of the country, but there are responsibilities of providers in the United States. We see this, by the way, if you've ever gone through the Medicare Part C certification process. This question in the that's required for screening by a Medicare Part C plan, ask the question typically: Do you have overseas providers, or are you using overseas resources? Are you transmitting PHI? And you've got to often demonstrate, you've got to answer that question in the affirmative and be able to confirm that you are transmitting the rules and establishing business associate relationships. So that is absolutely something that we're seeing. We're seeing it much more pushed by federal health programs than under the auspices of the Department of Health and that under the HIPAA auspices. It's all Department of Health and Human Services, but that is very important. Even though HIPAA doesn't really have enforcement powers within it over overseas providers, anybody who is a covered entity that is shifting information, or business associate that's putting information overseas, needs to make sure that the entities in those overseas locations are understanding and complying with HIPAA. And so it's a great question. So we want to finally just close with sort of potential impacts of these changes that we've gone through in HIPAA and Title 42. Are they beneficial or harmful to healthcare providers? Are they beneficial or harmful to patients or consumers? These are interesting questions we're going to see. I personally think there's clearly an effort to do more to protect patients. Some of these provisions are going to streamline some things for healthcare providers, like we've spoken about, but it's really a mixed bag. And I think these are going to be interesting, important questions to keep looking at as we go forward. Likewise, interoperability. The government has pushed on this. It sort of does feel like the big spending on this at a federal level is over. The anti-kickback statute, safe harbors to allow for EHR subsidies, for example, have gone away. We are where we are, right? Interoperability has definitely improved. We're not in a fully interoperable system, but as I suggested, I'm not sure we fully want to be.
Right.
This whole system raises all kinds of very interesting privacy questions. I think this is a net positive for substance abuse providers because Title 42 has been such a murky area of law. The question, my favorite question on here is in the upper right. You ask, what will this mean? What with a higher patient involvement in their own records? What will be the outcome of higher patient involvement in their own health records and their own management? And I think, in many ways, there's a story of haves and have-nots, of part of the U.S. population really doing great things with their own health information, and most of the U.S. population probably doing very little. Any thoughts?
No, I think you've hit it right on the head, and I think we're going to see how this is implemented and the consequences of it. We'll see if any kind of systems, any kind of professional associations, how they're going to adapt, how providers are going to adapt in general, how this will even affect the court systems. There were those prohibitions described on limiting substance use disorder information in legal proceedings. So I don't know how much that's going to change, but perhaps we're going to see a decrease in discrimination against people suffering from addiction in low-income communities. We're going to see different changes all across the country.
So we still have 3 more webinars to go in this series. It was a big, ambitious project that we're excited for. The really kind of brand new stuff that I really hope people will join us for will be next month, when we talk about the FTC emerging as the sort of bulldog in health privacy enforcement. We're going to talk about state law and how states have really closed the gap in our July webinar, and then a forward-looking closure in August. So it's been a pleasure, Adela, to do part 2 of this series with you, and really looking forward to sharing ideas on how much health privacy has changed and is changing ahead.
Definitely. And you can always contact us here. Here are our email addresses. Feel free to contact us with any questions you might have, and we look forward to seeing you next month.
Thanks.
Thank you.